And hello, everybody. Thanks for coming to this presentation of civil rights, due process, and the deportation cases. As you probably know, there's been a lot going on these days since the new administration came on board, having to do with immigration, among all the other issues, policy issues that are being debated and acted on. But in the immigration field in particular, the tension that exists between individual rights, civil rights, liberty, and the government's great power and arguably overreach or abuse of power. That tension between the power of the government and an individual's liberty rights comes into very, very clear focus. So I want to talk about that today. And there is so much going on in the area just of immigration and deportation rights that I am not going to cover all of the various lawsuits going on against the government involving immigrants and deportation. There's just way too many of them. I'm going to focus on the deportation cases that involve removal of immigrants to a mega prison in El Salvador, primarily. And I am not an immigration lawyer, and I do not know the ins and out of immigration law or of the procedures for removing illegal or legal immigrants according to the administrative law that exists for immigration. But I am a civil rights lawyer, and I know something about the Constitution and something about various court rulings and Supreme Court rulings interpreting the Constitution and how it must apply even to non-citizens, even to people, immigrants who have come here either under all the legal processes or even initially without legal process. So really, what I hope the presentation will highlight is this tension I mentioned between how far can the government go in exercising its great powers and what limits exist on that power to protect individuals, even non-citizens. So next slide, please. John Locke, famous Enlightenment professor, said, "Wherever law ends, tyranny begins." And really all that means is that without a rule of law, without procedures that in some way restrain the power of the government, of the state, then that sort of overreaching power really is nothing more than tyranny. And where that line is something that I think is being hotly debated now. Next slide, please. So let's talk a little bit about what due process is, because that's really a fundamental civil right in this country, is to have due process, whatever that means. Of course, the goal of due process, again, is to protect individuals and individual liberty from abuses of government, overreaches of government. Lord Acton famously said that power corrupts and absolute power corrupts absolutely. And Alexander Hamilton wrote how while you must enable the government to be able to control the governed, in the next place, the government is obliged to also control itself. How do we do that? Next. Ben Franklin basically said it's better that 100 guilty persons should escape than one innocent person should suffer. And according to him, that was something that was long and generally approved of and well known. And that again highlights the tension between expansive government power versus individual liberty, the right to feel free to do whatever and say whatever you want, so long as it doesn't injure somebody else. Next slide, please. For instance, in literature, we've seen examples of people imprisoned without any sort of hearing, any due process. If you've read A Tale of Two Cities, Dr. Manette was anonymously accused and imprisoned in the Bastille for 18 years. because an aristocrat told the state to put him away. Next. Likewise, if you've ever read The Count of Monte Cristo, another story involving an anonymous accusation and imprisonment because of the power of the government to do that without any hearing whatsoever. Next. So a brief history of due process. How did we get here? Here in the United States, we come out of the English tradition, of course, and going back to Magna Carta in 1215 AD, when the noblemen under the feudal system were able to exercise some of their power, some of their leverage to get the king to agree, for instance, that no one would be seized and imprisoned except by the law of the land, some sort of recognition that some process of law, of standards had to apply. It could not be done without any restraint. Next slide. And what we call the Great Writ, habeas corpus, produce the body. You should have the body, bring the body, which is basically a court order compelling the government or the state to bring a prisoner out of the prison to a court to have a judge, an independent judge, review the accusation and the evidence against the prisoner. Interesting, just last week, we heard the Homeland Security Director asked at a Senate hearing to explain what habeas corpus was, and Kristi Noem basically got it exactly opposite correct. She said that habeas corpus is a constitutional right that the president has to be able to remove people from this country. Whereas, again, what it really is the ability of an independent judiciary to have an accused, imprisoned person actually brought out of the prison to a court of law to hear the accusation, to hear the evidence, and to in some way act as an independent check on this unrestrained power of the sort you see in the Bastille or the Chateau d'If. Next. And of course, the United States Constitution itself specifically references the privilege of habeas corpus. It shall not be suspended unless in time of rebellion or invasion. And in fact, Abraham Lincoln did suspend the writ of habeas corpus during the Civil War that was deemed controversial. Next slide. The Fifth Amendment of our Constitution and the Bill of Rights says no person shall be deprived of life, liberty, or property without due process of law. And the Sixth Amendment, on behalf, in particular, of criminal accuseds, say that a criminal accused shall be informed of the accusation, what it is all about that they're accused of, be confronted with any evidence, including witnesses against them, and to be able to compel witnesses, if they exist, to come to court to testify in the accused's favor and to have assistance of counsel. Next. The 14th Amendment, which was one of the post-Civil War amendments, made that applicable to all the states. Previously, it was only the federal government that was under this compulsion to apply due process of law. Now, that's an exaggeration. Each individual state, of course, has their own constitutions, and I'm not an expert on 50 state constitutions, but I'm pretty sure they all guarantee some level of due process. But to the extent it had been interpreted by the United States Supreme Court, by the 14th Amendment, those interpretations were made equally effective as to all of the states. Next. Accusation is not proof. A conviction has to depend on evidence and some orderly process. So what is due process at its heart? Next. Basically, it's as simple as notice telling the accused what it is they're charged with, what the nature of the claim against them is, and some opportunity to be heard, some kind of hearing before a judge for the accused person. What form that may take may vary. In a criminal case, everyone in this country is guaranteed the right to a jury trial to hear that. In some various administrative law uh, uh, areas, such as immigration, there's not a right to a jury, but there is an opportunity to be heard by a judge and to have the evidence tested before a judge, not just have a prosecutor on behalf of the state throw people in jail based on an accusation without any kind of hearing or evidence. Next. And who is entitled to due process? In this country, under our Constitution, it's any person physically present in the United States. They have a right to some due process, some notice of what it is, and some hearing with evidence deemed admissible or inadmissible. And what happens if you are then physically removed to a location outside of the United States? Next slide. The George W. Bush administration tried this with Guantanamo Bay in Cuba following 9/11. And they set up these independent military commissions that were administered solely by the military without an independent judiciary being involved. And the idea was to have an alternative hearing system that was not independently checked by the judiciary and that habeas corpus did not apply to. They had their own idea of what they thought would constitute due process for those quote unquote enemy combatants that were seized in Afghanistan following 9/11. And it took until 2008 for the United States Supreme Court to decide that habeas corpus applied even to those prisoners outside of the United States being held in Guantanamo Bay, Cuba. The idea had been that by removing them from U.S. territory, no due process rights under the U.S. Constitution would apply. But the Supreme Court held that because Guantanamo Bay was under the control of the US and the US military, that therefore basic due process rights, as we understand them, had to be applied even there. And that included the right of habeas corpus. Next slide. So, what happens if you try to remove people outside the control of the United States, say to a foreign prison? And that brings us to the El Salvador Terrorism Confinement Center. The president of El Salvador wrote that he has helped the US to outsource part of its prison system. And they have been paid for that privilege. They've been paid $6 million for the cost to house so-called terrorists from the United States. And a White House spokesperson has said that that is pennies on the dollar of what it would cost to house these people in the United States, these prisoners. So what happens when persons are accused and sent to a foreign prison? Next slide. Well, this is beginning to be tested in our courts now. And in one of the cases that we'll talk about a little bit more involving Kilmar Abrego Garcia, part of the procedures in that case has already reached the Fourth Circuit. And in a Fourth Circuit Appeals Court decision, the court has asked, well, what happens if the government is claiming the right to deport people without due process and even perhaps in disregard of court orders, which appears to be happening, as we'll discuss. What are the assurances that that won't be applied to other people, to American citizens? And once they're gone to a foreign prison, who's to say anybody has any responsibility under the Constitution to bring them home? Next slide. So this El Salvadorian mega prison has been used to send prisoners that the government claims, our government claims they're entitled to do under something called the Alien Enemies Act, which the Trump administration has invoked. And on March 14th, President Trump signed an executive order invoking the Alien Enemies Act, which under its terms would permit deportation without notice or hearings, as may be otherwise required under immigration law. And the basis for invoking the act was that one particular Venezuelan gang known as Tren de Aragua has supposedly infiltrated the United States and is conducting irregular warfare in conjunction with the Venezuelan government. That's the claim of the current administration as a basis for invoking this quite overarching 18th century law. Next slide. What does that 18th century law says? It says when there's a declared war between the US and a foreign nation or government, or if there's been an invasion or a predatory incursion against US territory by a foreign nation or government, then all natives and citizens of that hostile nation or government, at least 14-year-olds, at least 14 years old, may be apprehended, restrained, secured, and removed as alien enemies. And it's that simple. Next slide. It's been used 3 times before the Trump administration invoked this law in 2025. In the first 2 times, there was the War of 1812, which obviously was a war in which we were invaded by Britain. And then 100 years later, during World War I, it was used to intern German immigrants, German nationals, German people who had not yet become citizens here, as well as Austro-Hungarian immigrants. Next slide. Next. And it was invoked much more recently during World War II. I'm sorry, let's go back one. There we go. World War II, during what happened was the internment of German and Italian nationalists, as well as internment of Japanese American citizens in a case called Korematsu. And in 1944, Korematsu, a gentleman, Korematsu had sued using habeas corpus to void the internments, and his suit was dismissed by the United States Supreme Court, who found that national security permitted the use of the Alien Enemies Act to intern Japanese citizens as they did in camps in California. In 1984, a group of lawyers actually brought the case back to the United States to hold that it had been wrongfully decided. And while the case was not technically overruled, it was held to have been in error coram nobis. And that case, among the lawyers handling that case, was Ed Chen, who is now a U.S. District Court here in the Northern District in San Francisco. And Judge Chen has been handling some of the cases involving Venezuelan deportees, not deportees necessarily to the terrorism center, but Venezuelans who had already been granted what's called temporary protective status. Venezuelan immigrants who were able to present a showing that they were entitled to political asylum. based on um, a threat of harm, political harm, physical harm, if they'd gone back to Venezuela. There are, I believe, hundreds of thousands of Venezuelans in the country protected by temporary protective status. And recently, the Trump administration revoked that status wholesale. Judge Chen issued a temporary injunction against that order, finding that it was likely made for capricious or arbitrary reasons, which would be against the law, as well as that it would cause irreparable harm to people who were deported pursuant to it, uh, and that that order should be restrained while individual Venezuelans on temporary protective status, while their individual cases were heard. The Supreme Court recently invalidated that injunction. Next slide. So based on the Alien Enemies Act, uh, the Trump administration on March 15 began flying folks who it accused to be part of this gang called Tren de Aragua, a Venezuelan gang, which, as we saw previously, they claim is acting so much in conjunction with the Venezuelan government and so much infiltrating this country that it should be deemed, in their view, to constitute basically an invasion, a predatory incursion, war under this 18th century act. And on that basis, on March 15, they began flying people to this Salvadorian mega prison, the Terrorism Control Center. Next. And almost immediately, lawyers from the ACLU were able to bring an application for a temporary restraining order to a federal district judge in Washington, D.C., Judge Boasberg. And it was early in the morning on Saturday, March 15, that some of these ACLU lawyers were getting calls from clients of theirs who had been brought to Texas, to Harlingen, Texas, a detainment center, an ICE detainment center, where they told their lawyers that they were being told they were going to be flown to El Salvador shortly. And they were able to reach Judge Boasberg, who was not in court. He was away for the weekend, but they were able to reach him. And he issued an emergency order that very morning on behalf of the specific individual clients that were represented by the ACLU. He issued a TRO immediately to prevent those persons from being flown out of the country on this claim of Alien Enemies Act. And he also set a hearing for 5 o'clock that very day. And it was only shortly before that hearing began that the government even announced that they had issued this executive order the day before, invoking the Alien Enemies Act. And at this hearing on Saturday, which was an online hearing at 5 o'clock, Judge Boasberg asked the government attorney if deportations and removals were imminent under that proclamation. And the lawyer said he didn't know. So there was a 40-minute recess taken for that lawyer to find out. And during that 40-minute recess, two of these three planes took off from Texas carrying these deportees to El Salvador, ostensibly under the Alien Enemies Act. Next slide. And after about 40 minutes, the government attorney returned and said that national security interests prevented him from giving any further clarification. The judge actually then went non-public in the online hearing so that the lawyer could tell him whatever he had to say about national security interests, at which point the lawyer told him, well, he just meant that at some future hearing he would be able to tell him more. He didn't have any further information about national security or anything else about whether these flights were going to take off. And at that point, the ACLU lawyers cited information to the judge that ICE was boarding these planes and having them leave even even at that very time during the hearing that was supposed to address the propriety of whether these flights should be leaving. So at 6:45 that very evening on March 15th, Judge Boasberg ordered from the bench that any such deportation flights based on the Alien Enemies Act be halted, and if they were already in the air, returned to the United States. So that he issued basically a blanket injunction after his hearing. Before the hearing, it was a TRO solely on behalf of the individuals that the ACLU had been able to contact in Harlingen at the detainment center. After the hearing, Judge Boasberg issued a nationwide, more wide-ranging injunction as to any deportation flights based on this Alien Enemies Act. Next slide. And it was about an hour after that that the third ICE plane took off from Texas for El Salvador. And the two planes that had already left arrived in Honduras on their way to El Salvador, and they remained in Honduras for several hours, just on the tarmac with the deportees, before they proceeded to El Salvador. This photograph is from those arrivals when they got to El Salvador of those deportees being off-boarded from the plane. And you may recall that there was a tweet the next day from the El Salvadorian president, which our Secretary of State reposted, saying, "Oopsie, too late," essentially mocking the court's order. Next slide. So who were some of these people who were deported? Obviously, I don't know who all 278 deportees under the Alien Enemies Act were, but information about some of them has been made public through their attorneys and families. And I want to highlight a few alleged, Tren de Aragua terrorist gang members who have been sent to this mega prison without any due notice, without any due process, without any hearing. So one of them is a young man named Andre Hernandez Ramirez. He's a gay makeup artist from Venezuela. He entered the US legally. He made a request for asylum. He did all the paperwork. He claimed he was a victim of persecution in Venezuela for his political beliefs. Of course, Venezuela is, I'll say, essentially a dictatorship, and that he was also a victim of persecution for being gay. And he passed the initial asylum screening, and he was awaiting further hearings, proper process in the United States. However, he was waiting in a detainment center and on March 15th without any notice and without a removal order because he was under the protection already of an asylum screening, but without any further process, ICE put him on this plane to the El Salvador prison, claiming that he was a Venezuelan gang member. Next slide. There's another young man named Ricardo Prada Vasquez, a 32-year-old Venezuelan immigrant, also legally in the United States. He was living and working in Detroit, doing deliveries. He picked up an order from McDonald's. He made a wrong turn and ended up on the Ambassador Bridge to Canada. When he drove back, he was stopped, and they sent him to this Texas detention center. And on March 15th, he was able to text to a friend that he was about to be put on a plane back to Venezuela. He was put on one of those three planes that was ultimately delivered to the El Salvador mega prison, the Terrorism Confinement Center. At least according to a government statement a few weeks later, that's where he is, because there is absolutely no record of him having been put on any of those planes. He does not appear on any manifest. There is no record of him in El Salvador. He has been effectively completely disappeared disappeared. Nobody knows where. Again, ostensibly, he is in that El Salvadorian mega prison, but there is no record of him. And without any record, uh, his family is not in a position to be able to even bring a lawsuit to try to have him brought back or try to have a remote habeas corpus proceeding or anything if they can't show where he is and how he got there. Next slide. So on April 7, the United States Supreme Court actually vacated Judge Boasberg's TRO, preventing any further removals under the Alien Enemies Act, the 18th Century Wartime Act. But they ruled on a very technical ground that it had not been brought in the right place. Judge Boasberg sits in DC, federal court in DC, and the United States Supreme Court said that it should have been brought where they had been held in detention, which was Harlingen, Texas. And most significantly, they held that the Fifth Amendment entitled even these aliens, non-citizens, to due process in the context of these removal proceedings. And they ruled that detainees under the Alien Enemies Act were entitled to receive some notice. They didn't specify how much notice, but as they said, within a reasonable time and in such a manner as would allow them to actually seek habeas relief, which would mean being able to get a lawyer to file papers in a court so that a court could order a hearing and the prisoner could be brought before the court, either online or otherwise. Next slide. In the meantime, Judge Boasberg still has jurisdiction over his original order and what appears to have been the government's willful violation of his initial order, even though the Supreme Court had vacated his TRO and now allows the government to proceed with Alien Enemies Act deportations given due process and the rights of habeas corpus. Despite that, there was still an order that had been issued back on March 15th preventing those flights and ordering that if a flight was still in the air, that it be turned back. And the judge still has jurisdiction over that. And you can read his order. I've given the link. On April 16th. He issued his order finding contempt. I will say that on April 2nd, there was a hearing Judge Boasberg had that I happened to be present for in district court in Washington, D.C., where he was trying to get to the bottom of the facts of government officials were told when they knew it, what they knew when about these flights on that day, and who was responsible for ordering those other flights to continue and refusing to bring back at least one flight. And I want to remind you again, as I said at the beginning, there are procedures under administrative law for deportations, for removals in an orderly process using due process. But once the Trump administration invoked the Alien Enemies Act on March 15th, they immediately began deporting these 278 individuals, a couple of whom I've shown you pictures of, immediately, without any notice, without any due process. So Judge Boasberg, in his April 16 order, has concluded that they seem to have willfully taken actions to get people on planes and out of the country to outrun the reach of the judge and the judiciary. And He points out that the decision to launch planes during the afternoon hearing he had on that very issue was especially egregious and suggests an attempt to evade an injunction and deny those aboard the planes the chance to avail themselves of judicial review. And in the courtroom on April 2nd, when the judge was quizzing the government lawyer, he really had him on the hot seat, and the lawyer just had to admit again and again that that the judge had been very clear in his ruling back on March 15th, that they had taken a 40-minute recess so that that lawyer could advise his superiors of what was going on and try to get the judge more information. The judge was really hard on this lawyer, and and this was the judge's conclusions in his order on April 16th. Next slide. Before we get to Kilmar Abrego Garcia, I will say that Judge Boasberg has given the government a chance to redeem themselves by complying with his initial order. That is, they can cure the contempt. He doesn't necessarily want to proceed with further contempt proceedings like holding people in civil or criminal contempt and issuing injunctions or even putting people in jail. He says the contempt can be cured if they do what they failed to do, which is provide some sort of hearing, some sort of due process to the persons who were illegally deported pursuant to this Wartime Alien Enemies Act. So far, it seems like there's been nothing but stonewalling by the government with regard to information about what happened that day on March 15th when they were flying planes in violation of his order. And we're going to wait and see what happens with that. So one of the most notorious cases we're dealing with in these deportations to this El Salvador mega prison is that of Kilmar Abrego Garcia. And it's one of the most egregious because the government itself has conceded in sworn affidavits that he was mistakenly deported from this country to this terrorism center in El Salvador. So Mr. Abrego Garcia had originally entered this country illegally from El Salvador. Uh, there were claims that his family business, Pupusa restaurant, was being extorted and threatened by the Barrio 13 gang that's quite active there. And his brother had earlier left El Salvador for that reason, to escape gang threats. And his brother was a citizen of the United States living in Maryland when Kilmar Abrego Garcia came to this country illegally. Eventually, Kilmar Abrego Garcia married and fathered a child, as well as being the stepfather of his wife's previous two children. Um, he was arrested for loitering at a Home Depot looking for work back in 2019. He was turned over to ICE at that time, and he was found at that time in 2019 to have a well-founded fear of harm from gang members in El Salvador. So in 2019, the federal judge issued a non-removal, withholding from removal order that specifically said he could not be deported back to El Salvador. Um, my understanding is it's U.S. law and even international law that you can't send people to countries where they have a well-founded fear uh, of physical or political persecution. There's plenty of countries in the world where you can send people, but if the person can prove that they would be put in harm's way by being sent there, and they're entitled to a hearing to show that. And again, Kilmar Abrego Garcia in October 2019 established that he had a well-founded fear of harm in El Salvador. So while when he was picked up in March of 2025 on a routine traffic stop while he was taking his kid back home, uh, I think ICE called the wife, his wife, and gave her about 2 hours to come and pick up his kid before they were going to send Kilmar Abrego Garcia to this detention center in Texas. Uh, But they sent him there to that detention center in Texas. And on March 15th, ICE put him on that third plane to El Salvador uh, under the alleged authority of this Alien Enemies Act, although the government now is calling into question which of the three planes was under the Alien Enemies Act and which was just people being deported otherwise who had had due process and were removal status was established. But in any event, next slide, he was sent there and uh, he's been identified in this picture, which is at that mega prison. And his wife brought a TRO that was heard on April 4 by Judge Paula Zinnes, who's a U.S. District Court judge in Maryland. And as I said, the government conceded that this had been done as a mistake. There was a sworn affidavit by a Homeland Security deputy director acknowledging that. And Judge Zinnes took immediate action. This hearing was on a Friday, the TRO, and she ordered that he be returned to the United States by midnight on the following Monday. And this is the case, you may recall, where the government claims that this is interfering with their conduct of foreign affairs. The guy's in El Salvador, and so it's all about diplomacy and foreign affairs, and that is solely in the jurisdiction of the executive branch under the Constitution, and the judiciary can't say anything about it. So again, this highlights this tension between how far can the government go in trying to remove itself from the limitations of due process and habeas corpus by trying to spirit people outside of the United States. It didn't work doing it to Guantanamo Bay 20 years ago, and the judiciary doesn't like them trying to do it now by spiriting them away to a foreign prison. And as Judge Zinnes said in her initial ruling on the TRO, she made clear that while there may be questions about the mass removal of people to El Salvador, one thing about this case, of Abrego Garcia's case, is categorically different. There were no legal grounds whatsoever for his arrest, detention, and removal. His detention is wholly lawless. Next slide. The lawyer who conceded that Abrego Garcia had been removed mistakenly, and again, there was already an affidavit to that effect from a deputy director of Homeland Security, but the lawyer who argued the case before Judge Zinnes has been suspended immediately for engaging in conduct prejudicial to the client. And the following Sunday, it was a Friday hearing, the lawyer was suspended immediately. And on Sunday, Attorney General Pam Bondi appeared on Fox News to talk about that hearing. And she said that attorney's statements to the judge were, quote, like a defense attorney walking in and conceding something in a criminal matter, which I want to highlight because what the government is saying, what the Attorney General of the United States is saying, is that the rights that a criminal defendant has under our Constitution, the rights of an accused to challenge the prosecution of the government, of the state, she seems to think that's a two-way street, and that the government has every bit the same right to not speak or to mislead when it exercises its extreme power to prosecute and accuse people, which, again, sort of like Kristi Noem's statement about habeas, I view as really the opposite of what the law is and the law says. The government has overwhelming power, and to the extent it can, the Constitution tries to restrain that power as to protect individuals' liberties. And Attorney General Bondi seems to have a very, very expansive view of the government power, and that it should be in every way comparable to the right of individuals to try to resist abuse of power. And I found that a really striking statement. Next slide. So Judge Zinnes, you may recall, whoops, back one, please.
Oh, did I go? Sorry.
Judge Zinnes ordered the government on that Friday to immediately facilitate and effectuate the return of Mr. Abrego Garcia by midnight that Monday. Again, the government claimed that was interfering in the conduct of foreign affairs. They went straight to the U.S. Supreme Court, which issued an order vacating Judge Zinnes's order, but instructing the government, nevertheless, to facilitate Mr. Abrego Garcia's return, and then returned the matter to Judge Zinnes. She promptly issued further orders directing the government to take steps to facilitate Mr. Abrego Garcia's return to the United States and to explain how this happened and what efforts are being taken. And again, the government has stonewalled Judge Zinnes in the intervening month, refusing to respond to discovery about what steps they've taken. Next slide. Some of her orders went up to the Fourth Circuit, and in that opinion, a three-judge panel has been very plain-spoken that the government is asserting a right to stash away residents of this country in foreign prisons without the semblance of due process that is the foundation of our constitutional order. And I think that really crystallizes things because, of course, when there is this tension between the power of the government and the liberty of individuals, it really does come down to the protections of due process. And if those are removed for certain people, in this case, residents who maybe are not yet citizens of the country or are immigrants, if that's established, then perhaps it can be done eventually to citizens and residents. Next slide. As the panel said, this should be shocking, not only to judges, but to the intuitive sense of liberty Americans far removed from courthouses still hold dear. Now, the government conceded it mistakenly deported Mr. Abrego Garcia. Why then do they not correct the error, make what was wrong right? Next slide. Next slide. In California here, we have some maxims of jurisprudence which include the concept that for every wrong, there is a remedy. That's a basic fundamental idea. If a wrong is committed, it must be corrected. There is going to be a remedy. The courts will find a remedy because that's basic fairness. Likewise, another maxim of jurisprudence in California is that no one can take advantage of their own wrong. If the government makes a mistake, it is obligated to do everything it can to remedy it. Next slide. Another quote from a Supreme Court Justice Hugo Black from about 60 years ago, noting that bad people, just like good people, are entitled to be sentenced in accordance with the law. And if someone is shown to be serving an illegal sentence, it is our obligation to take steps to correct the wrong that was done. Next slide. So are we approaching a constitutional crisis where the administration has been sending people to a foreign prison in violation of various TROs, including by other judges I haven't talked about? There's a case up in Massachusetts where a district judge ordered the administration not to proceed with deportations to countries not where the persons removed, it was not their origin country. Because again, ICE was not giving people due process and opportunity to explain if a particular country was dangerous to them, could harm them. And these are recent flights to Africa of various immigrants, now deportees, who were not from Africa. So you've heard talk about whether there's a constitutional crisis brewing or not. I would say we are witnessing a slow motion constitutional crisis. In that same Fourth Circuit Court of Appeal decision, which I recommend to everybody to read, it's all of 4 pages and it's very clear, puts things in perspective. In that very case, they cited the example of President Dwight Eisenhower, who did not agree with the decision in Brown v. Board of Ed to desegregate schools, but he nevertheless enforced it and sent National Guard into schools in Arkansas to protect African American children, desegregating, integrating schools there. And the judge in the Fourth Circuit case quoted President Eisenhower an address he gave about that in 1957, where he said the very basis of our individual rights and freedoms is the certainty that the president and the executive branch will support and ensure the carrying out of the decisions of the federal courts. So, will the executive branch respect the authority of the judicial branch in enforcing individual liberty, individuals' rights to due process and habeas corpus against a comprehensive effort to deport people as fast as they can? History gives us another lesson. Next slide. Back in the 1830s, the executive branch actually decided not to respect the decision of the U.S. Supreme Court when the Cherokee Nation were effectively evicted from the state of Georgia, from their territory that had been granted to them by a treaty with the United States. And the U.S. Supreme Court overruled that. And President Andrew Jackson famously is rumored to have said, John Marshall, the Supreme Court Chief Justice, John Marshall has made his decision, now let him enforce it. Of course, the judiciary in the United States does not have an army, does not have a police force, relies on the executive branch to enforce its orders. Next slide. So in closing, the famous Shakespeare quote, the first thing we do, let's kill all the lawyers. It's not because we lawyers are obnoxious and annoying, even though we are sometimes. It's because we know the law and we try to enforce the law and we know how to seek enforcement of the law from the judiciary branch. And that's the end of the presentation. I'll take some questions. I see some questions in the chat.
I can,
Christy, or Francie?
yeah, I can read them. I had asked if the Garcia case was back in the Fourth Circuit now, but I think you answered that. It is, right? Correct. And then there is a kind of a long question. With the possibility of the big, beautiful bill maybe passed by the Senate and the provisions made non-bond contempt charges by judges non-enforceable remaining, do you think the judiciary will begin issuing a bond-based contempt rulings in the future?
Well, as I understand the question, there is something in this, what is essentially a budget bill, about requiring federal courts to require a bond in order to maintain an appeal. And right now, a federal judge can waive that requirement. This would mandate it. I've read that the parliamentarian says it's not, that provision is not properly in the bill in the first place because it's a budget bill and it's being passed, if it passes ultimately, with budget reconciliation laws that don't require the required filibuster proof vote of the Senate. But is the question, do I think the judiciary will begin issuing bond-based contempt rulings? Do you mean they'll uh,
Well, I can tell you the second part of the
yeah,
question as well. Um, I was breaking it up. Since the bill is retroactive on this, is there a possibility to amend previous contempt charges, injunctions, and TROs to add security?
to add that security aspect, to require existing TROs to now maintain bonds. Yeah, I think that's the whole idea of the bill, is my impression, simply from reading what I've read in the newspapers. It's the government trying to limit the reach of the judiciary by limiting the ability of the litigants to call on the judiciary by requiring them to post a bond every time, which can be very, very expensive. Maybe nonprofit organizations can help solicit those bonds. But again, as I say, it may prove to be an illegal, unlawful aspect of this particular budget bill. Any other questions?
I have one. Was Andrew Jackson ever held accountable for not following the court's order?
No, no. It's one of these um, events in history that have been largely lost to time. But no, the Supreme Court can't or didn't try to hold him in contempt. Who knows what would have happened then? And of course, the case concerned indigenous people, and who cared about them in the 1830s? Just like I think now a lot of people in the administration are hoping, who cares about illegal immigrants? That's who they're going after first. And which is not to say there have not been problems with the border or problems with handling the load of immigration cases. Although I will say that border bill that was close to passing back in 2024, my understanding is that would have provided about $450 million for new immigration judges. So it's not a matter of there not being a process that can handle the scope of the problem. It's the resources not being dedicated to the proper process that already exists to lawfully handle the problem, and instead trying to just go around it and throw people out without due process, which I think inevitably leads to excesses, such as the case of Mr. Abrego Garcia, who's now in a, you know, high security terrorist mega prison, as well as some of those other people I pointed out, Andre Hernandez Romero, who, what do I know? Is he really a gang member from Tren de Aragua? It doesn't seem so based on all the evidence and testimony from his family.
However, a question I have is though, if they were erroneously deported, they're not illegal aliens then, correct? Because they were never found to be illegal, or they're not necessarily illegal aliens.
So again, I'm not an immigration lawyer, and
Oh,
I'm not even up on all the technicalities of the terms of art. But I can tell you that people who are residents of this country are entitled to due process, and you can't just snatch them off the streets and send them to a prison in El Salvador and then wipe your hands of it and say, "Oh, gee, not our problem. They're not here." Uh, they tried something like that in Guantanamo to say, oh, gee, you can't reach us here. Well, they can. And there are ways to have hearings remotely to provide some due process. The judge in Massachusetts that I mentioned, dealing with people being deported far away to countries that are not their countries of origin, he has proposed that they be provided uh, a hearing remotely from wherever they are now, whatever country they've stashed them in on this plane while it's waiting to proceed to the Sudan or wherever they're sending Djibouti. There are ways to have remote hearings if you're
okay.
not going to actually bring them back here for a hearing.
Okay. We have another one. Can improperly deported immigrants get any damages from the government for their pain and suffering and denial of rights?
Short answer is I don't know. Longer answer is I certainly think they should. And if they could maintain that claim under the civil rights acts that exist, maybe they'd get lucky and win. Maybe somebody like Mr. Abrego Garcia in a situation where it's clearly an error. There's huge discretion applied to the government in its determinations when it comes to uh, immigration proceedings, uh, which again is why it's just so egregious, this overreach of power, in my view, using the Alien Enemies Act and other, because again, procedures exist and the discretion is quite broad in the context of those procedures to deport people. Now, I know there's other people watching this presentation who are immigration lawyers and
Yes.
probably know better than I. Give me a thumbs down if I've said anything
No, no, it's
incorrect.
good. It's good.
I'm getting a thumbs up.
David, I've been reading there's some US citizens who are accidentally swept up and being deported, and then they release them after like a day to a few days and say, oops, oh well. As Trump said, mistakes will happen, right?
Yeah.
But
They
they
are.
need to sue for damages and sue for every nickel and dime they can get. They need to
Yeah.
sue.
And as a civil rights lawyer, I'll tell
Yeah,
you,
get what they
rarely
can.
do people who have been detained for a few days with no physical injury, or rarely are those seen as very
Over.
compelling cases. But certainly something like what has happened to these people swept up and sent to a foreign, mega
Yeah,
prison terrorists. Uh,
it's scary.
as that Ben Franklin reference made, the I more important that innocent that somebody who's guilty of something goes free than that innocent people go to jail, and the suffering that they experience there should call for moral outrage. And so the idea that this administration says they don't have to do anything or they're not going to try to do something, even where they admit they have made a mistake. They are unwilling to correct a wrong that has been done to an individual by the power of the state. It's well, it's the road to what John Locke said. I mean, without the rule of law, it is, call it tyranny, call it what you want to call it. It amounts to the same thing if the government can do that.
Okay. All right. We have time
Is
for
the
maybe
government
one.
being is the government being held in contempt for their mistakes? They you mentioned that they were getting, hey, bring him back and we won't hold you in contempt. But there's got to be a timeline for that. It's not has
So So the closest we've gotten on that, I think, is Judge Boasberg's order, where he has found them in contempt, but he has given them a chance to correct the error, to undo their contempt, shall we say. And I think that the judiciary obviously is reluctant to have this head-on crisis, this head-on conflict between the judiciary and the executive. Because what happens then, as my last two slides show, on the one hand, one president will acquiesce for the good of the country despite his personal beliefs. Eisenhower with Brown v. Board. Another president, 100 years ago, doesn't see it that way, doesn't care about indigenous people at the time, and said, you know, screw you, US Supreme Court. I'm not going to do anything about it. So I think the jury is still out on what's going to happen here and now. Uh, but the judiciary has to keep pushing for these minimal, fundamental due process rights that I show has a very long history, uh, and in the tradition that we come from, the English common law.
Okay, we have time for one more question. I would like to attendees to know that Ms. Lucy Lee is an immigration attorney, and she did have a presentation, and she confirmed that uh, there's no such thing as illegal immigrants, right, Lucy? It's undocumented. There are undocumented immigrants, which can happen even if you forget to sign some of your paperwork or there you forget to answer a question on your paperwork. So those are undocumented immigrants. And then we have one more question, one last question. Are there any class action lawsuits pending against ICE? Is ACLU sufficient to bring prosecution against the government, or is there another legal organization that is effective in prosecuting efforts? I think the answer is there are many more
Well, there are,
organizations, and I would imagine the ACLU, I'm thinking that maybe they'll be the ones who sue for Garcia's civil cases that
maybe
hopefully.
so. I think that the ACLU and so many other nonprofit organizations are so consumed right now with simply trying to protect people, litigating these overreaching efforts to deport people all over the country in so many different contexts. I've just highlighted the ones with regard to this Alien Enemies Act and the El Salvador mega prison. But whether they'll eventually get around to suing for damages, that's a different kind of a lawsuit. It's a civil lawsuit for damages. And I think, as I say, the immediate concern is just challenging government overreach with TROs, injunctions, and litigation over the constitutionality of using the Alien Enemies Act or other deportations without due process to countries not of your origin, to halfway around the world. So I think they got their hands full with the lawsuits that they have to pursue right now.
I have a question, and this
Sure.
may be irrelevant. So, not too long ago, this judge, he or she was arrested, supposedly accused of hiding an immigrant. I mean, she's a judge. I mean, what? I just can't imagine a judge being arrested. So we're giving too much power to basically the administration. So I don't know what happened to the status of is she released or so forth. I mean, as a judge and then as a person, I mean, her civil rights was violated.
Yeah, we can't have any we can answer this one last question, but we need to stop. We're
Okay.
8 minutes over, okay?
I'll just say that I believe that judge has a motion to dismiss as a matter of law pending on that. But I do think it illustrates again this overreach and this tension between the power of the state, of the government, and individual liberty, and how far this administration is going to go in that pursuit of that use of power. We'll find out.
Okay, thank you very much. I'm going to hand it over to Kristen now.
All right. Thank you so much, David. That was extremely fascinating presentation. I think we all learned a lot. As you can see, we don't even want to finish over our time. Just want to let everybody know that the copy of David's PowerPoint, as well as your evaluation for MCLE or CCLS credit, will be emailed to you in the coming day or days. And also always check the SFLPA website for upcoming brown bags and other events. Very exciting. We now have live the ability to buy tickets to our Giants game, which will be a September 27th, which is a Saturday, 1:00 day game. That'll be a lot of fun. So go on the website, buy a ticket if you're interested. We hope to see you there and see you at the next brown bag. And thanks again, Jason, for your time today.
Thank you, everyone.
Thanks, everyone. Goodbye.